use the names of any victims or minors, as I just noted that the arguments are being recorded and they will be on the internet. If you're the appellant and wish to reserve time for rebuttal, you may reserve up to 5 minutes. If you let me know when you get started, I'm keeping charge of the clock. You can also reference it on the wall. The judges have read your briefs. We're ready to proceed when you are.
May it please the court, Your Honors. My name is Cary, Hendy. I'm representing myself pro se. I'm in my almost 3 months shy of 10 years of one administrative hearing procedure. I'm here.
Mr. Hendy, before you get started too far, would you like to reserve any time for rebuttal?
Yes, ma'am, I'm sorry, I apologize. I'd like to reserve 5 minutes.
Thank you.
No, thank you, I apologize that I went straight to things. I'm an anxious person. I even have a service dog that I didn't bring because I didn't think it was appropriate. But so I am here, obviously myself, against the state of Ohio and the state of Ohio Attorney General section on civil rights. I'm really not here about my briefs and to argue about the petition for judicial review of a final order. I believe my briefs and my rebuttal were pretty clear. I'm really here because it's a bigger picture, and then I hope the court read read all of it and asked me questions, because I have 9.5 years of experience to try and jam 10 minutes of what I would talk about, and I can talk about it at length because it's been a huge detriment to my life. Opposing counsel says that I wish to vilify the agencies and not be accountable, and the reality is in life I'm always accountable, and I'm standing here 9.5 years accountable and asked to be here in front of you guys because oddly I'm kind of envious of the spot and the pieces that you guys are. You guys get to make a difference. You're what's called extraordinary. You're, as Ms. Carr says, Your Honor Carr says, there's 69 of you, and 69 of you affect 12 million of us. And I'm just one person, but I'm one person against 2 agencies. So what I'd like to do, if possible, what I consider is kind of want to shed a light on things that are really big and bad. The 2 state agencies are so omnipotent that they literally don't do their job, and then they administratively change the laws to not do anything, and the accused is automatically auto-guilted to never be able to defend themselves, to be innocent. So if I may do that, I'd like to just go down through a little bit of that and kind of, I guess, shed a light for other people. Okay, so so we're here to argue what's called a petition to review a commission final order. Just reading that alone tells you, excuse me, that really the commission and the Attorney General section on civil rights want you to just look at the final order. There's no scrutiny over to what they do, how they proceed, any of the pieces that they do. If anything, they wish to have everything deferred to them and argue to have it deferred to them, and ultimately to a set of testers that they claim testers are legal by Havens versus Coleman in 1982, which actually is not true, because there's several testers in Havens versus Coleman, but we're not here to argue that. But they only gave one tester the ability to actually sue for standing for damages. That doesn't make testers legal, but since 1982 up until 1985, federal prosecution then started using that as testers were legal, and it's really still, before the Supreme Court, has never been really argued in, to my knowledge anyway. So to this point, so what I would say is, this is going to sound a little weird, but I relate things to our lives. So I'm getting old now, I'm 55 years old, and I still remember, and as I hope you guys do, the first video on MTV was Video Killed the Radio Star. That was 1981. At the same time was Havens versus Coleman. 42 years from that point, the world has changed. So has the different things that should be looked at in regards to that decision, which was standing to sue, not a tester is legal. And definitely a tester being legal is not to be just relied upon without the probability or the actual scrutiny of how many tests. Did I flip a penny once and I wanted tails and it came up tails one time, so you're automatically, every time in life it's going to be tails. That's what the state of Ohio and the Attorney General section on civil rights, they have a responsibility to everybody to verify that, to check that. In my brief, I rebutted the appellant, Mr. Oppenheimer's brief here. And in this brief, it actually goes, and right into the first page, it says, Fair Housing Contact Services alleged that it performed testing, which if you look at the record, the testing was done in August and September of 2014. So they said that they filed a charge of discrimination on December 31st of 2014. When you read the actual law for what the commission is supposed to do is 4112.04A6, and it says, the commission shall do all of the following: receive, investigate, and pass upon written charges. So just literally reading the law, receive means they had to have received a written statement under oath before any investigation was to take place. That's step number 2, receive, investigate. But in this case, even in the brief, opposing counsel admits that, well, it says now the testing was alleged, but the testing took place 4 months before they actually made an accusation, and the accusation is made because what's happening is the federal government through HUD is pushing money down into the states, and the states are now pushing it into fair housing pieces through HUD, and they're actually illegally policing housing to the point of they're out testing, and Akron has 2 testing agencies. There's more policing agencies for housing than there is for actual criminal laws. In regards to that, give me, if I may take just a moment, because I'm starting to get a little. Okay. So, I'd like to clearly assert once again, the Ohio Civil Rights Commission is literally breaking its own law by changing it administratively. It's abusing discretion in the statutes of 4112.04A, 4, and 5, where it's allowed, to adopt and promulgate new rules, and in those new rules, my brief walks it down, but they literally have deleted the duties, statutory duties, to have a written statement under oath, which means someone is no longer accountable to when they accuse somebody else. And then they also deleted the duty to investigate the charges written under oath, and now they physically go and they rely upon, and this is in the appellate's brief, they rely upon those investigations by vigilantes that aren't in the law. They're not written anywhere in 4112. Federal law, they're not written either, because there's no sequence. In Ohio, there's at least sequence. So the sequence, they literally take no sequence anymore. The testers come and test you relentlessly for months beforehand, then they accuse you and you're automatically guilty. By the Civil Rights Commission getting rid of the duties, they no longer do anything to the accused. The accused is automatically guilty, and it's really, I'm 9.5 years trying to fight my way out. So, to that piece, from there, in revised code 4112.052, which is now .056, the Attorney General was made a partner with the Ohio Civil Rights Commission to represent them. So if I may, I'd like to tell you a little bit of my story, how I started figuring this out when it was happening to me. I got a letter in the mail. When I got the letter in the mail, there was a form with all the boxes, and every single box was checked. I violated every single thing you could discriminate against. From that piece, I wondered, what do I rent to? Who would I rent to? Now, mind you, this was my first and only house, and that becomes pertinent later. So I actually then I made a couple phone calls, and then I got invited to a conciliation. I got to the conciliation, and I was put inside a room, and on the other side of the room was a table of about 12 different people, and they said that I had offended those 12 people, and that I owed them $10,000 because they probable caused me to being guilty. And I said, no one's ever talked to me, no one's ever asked, no one's ever talked to the people that rented the house, no one did anything, but I'm supposedly auto guilty. And they said, well, yeah, that's correct. And I said, well, then I'd rather go to court. So I left, and when I was leaving, I was addressed by the counsel before Mr. Oppenheimer, who pulled me aside in the elevator, and I remember standing there watching and listening to him, and the first thing he said to me is, Mr. Hendy, we got you. And I thought, who's we got you? Who's we? You're the Attorney General. You should be a neutral party, and so should the commission. And I just couldn't get past that, so that made me start thinking of it and starting to pay attention, and that's when I learned everything that happens, that I put in my brief. To that, what I would say is that no matter where.
Could I interrupt?
Oh, yes, ma'am, I wish you would, because I'm rattling.
Well, just for you to know,
Yes, ma'am.
with our, the way our court works, we can only consider what is in the record. Okay, so any like conversations you would have in an elevator or something like that, unless you
Yeah.
put it in an affidavit or something else, then
Okay.
we can't consider that. I know you, like you said, you're kind of like just saying stuff, but I just wanted you to know that and for future reference as well as our review of this case.
Yes, ma'am. So then I apologize. I was just telling you the story of it, which is my process of just sharing the story. So I understand that it's the record and the argument has to be on what the court can review of the final order, which, once again, that's already established. Even Mr. Oppenheimer's own case in 1997 established that the court is allowed to look at constitutionality of legal procedures, all kinds of different things, not just what they want you to do of defer to them, and then they defer to testers, and really nobody has any accountability.
And I need to stop you and let you know that
Yes,
you're
ma'am.
reaching into that 5 minutes that you wanted to reserve for.
Oh, I'm good then. I apologize. Thank you.
No need to apologize.
And I do sincerely make apologies for my rattling and kind of tremoring. I get a little nervous. But thank you both.
May it please the court, my name is David Oppenheimer and I represent the House Civil Rights Commission. Your Honors, testing is a well-established method of detecting and combating discrimination. I cited just some of the cases in which various courts have applied testing, have looked at testing. And the Fair Housing Contact Service, in fact, tested Mr. Hendy's rental practices, and for 2 of the tests, he failed.
Counsel, I noticed
Yes.
that most of the testing cases that you referred to were outside the state of Ohio.
Correct, they're federal. We've had some testing cases within the state, but they usually haven't, gone very, very high up. So the Ohio Supreme Court has said numerous times that in looking at 4112 and what stands as a violation of 4112, it's very appropriate to look to federal cases for guidance. There are more of them since you have, the entire country as opposed to one state. And the statutes are written the same for the most part and meet the same purpose. So it's fully appropriate to look to federal cases when applying Ohio law. And I would note that there's certainly no case in Ohio that says that testing is not valid and the testing evidence cannot be used to prove a violation of law. Your Honors, the Commission held a hearing in which the testers testified, presented their evidence. Mr. Hendy testified and was free to present any evidence that he wanted to present. He wasn't auto-guilty, he wasn't guilty before the hearing. And I would note that Mr. Hendy did certainly choose to represent himself. And while there's some leeway given to pro se litigants, they are expected to follow the rules in terms of procedure, in terms of raising issues at the correct time. And there's an important reason for that here. In his answer, Mr. Hendy only denied 2 things that were in the Commission's complaint. 1, that he broke the law, and 2, that conciliation was properly attempted and failed. He didn't deny there was a charge. In fact, here today, he admitted receiving a charge. That's the paper with the boxes. He had received the charge, he knew he did, so he didn't deny it in his answer, correctly so. Therefore, those are the 2 things that the Commission focused on and proved at the hearing, because everything else was deemed admitted. As he's gone along over time, at different points, for example, in his post-hearing brief, he acknowledges he received a charge. In the objections, he doesn't say, well, I never received a charge, no charge was filed. He then starts to reach for different issues, but it's important for fairness that if he's going to challenge something, it has to be challenged at a point when the Commission then sees it's being challenged and can present that evidence at hearing. Because there's 2 steps, really, to this process. The pre-complaint step and the post-complaint step. With the pre-complaint step, commission receives a charge, as it did from the Fair Housing Group, and then it says, okay, complainants, what do you have, what law was violated, and what do you have to show that? And that's the tests. He's trying to claim that the tests were the investigation. That's simply not correct. And again, I'd note, he didn't deny the commission engaged in testing below, and under the Ohio Supreme Court case law, it's up to the commission to decide how much of a test to conduct, what the test involves. So you had the violation.
Let me interrupt you because it gets a little confusing.
I'm sorry.
No, you're not doing anything wrong, I'm just saying I'm getting a little confused with everything. So you're saying that the testing does not constitute the investigation that the Ohio Civil Rights Commission engaged in?
Correct.
What is the investigation then?
Well, the investigation is, after the charge is filed, whatever the commission deems necessary to determine if there's a violation. Here, there was no denial that the investigation took place. And again, under the case law, it's up to the commission of whether to do an investigation at all. It's not a jurisdictional requirement, so there's no need to say, okay, let's, in every single case that goes to hearing, let's redo the investigation. Let's get the investigator up there. But what happens is a charge was filed, and I can only conclude that Mr. Hendy said he had some calls. So we would have gotten some calls from the commission investigator, okay, what happened? And they would have looked at the tests, they may have spoken with the testers, and then said, all right, there's enough here to take this forward to the formal process of a hearing.
And what is that standard?
Probable cause,
Okay, probable.
which is under the discretion of the commission. Is there enough here that we're going to start gathering formal evidence and have a hearing where the rules of evidence apply? Prior to that, it's very ex parte, it's very informal, just gathering the information to say, is this something we choose to prosecute? Is this something where we feel that there may have been a violation? And when you have these tests and you have these testers, then it becomes very clear, oh yeah, here's the violation. So for example, let's take a different kind of case. Let's say it was a termination case. I was working for this employer and I was terminated based on my sex. So you get the charge. Okay, you contact a complainant. Why do you think you were terminated based on your sex? Maybe they say, I don't know, no particular reason. Okay, respondent, why'd you terminate her? Because she missed work 72 days without an excuse, and that violated our policies. Did you miss work 72 days? Yes. Okay, well, there's no probable cause. Let's say instead she says, well, he told me I had to sleep with him to keep my job. And I have a witness. And the commission says, okay, we talk to the witness, they verify it, respondent can't give us a good reason, that's going forward to prosecution. So it's whatever's needed by the commission.
Well, that's a simple example. I don't mean, I understand, I appreciate you making that analogy. But in these situations, like in the analogy that you're talking about, you don't have somebody from the outside going into an employer's workplace and asking questions that would compromise the employer. In other words, you don't have testers in that situation. So this is a little bit different, isn't it?
Not
Because you had the complaining party there that actually.
Well, it's not for the process. It's still, you receive a charge and you say to the complainant, you believe that the law has been violated. Why? What information can you give me to show that? In this case, it was, here are our tests. Oh, okay, these tests show a violation of law. Mr. Hendy, as he said, he received calls, he responded, and the commission's determination is, we're going to move forward and prosecute this. And at that point, we have a hearing, the transcript of which is in the record. The testers testified, Mr. Hendy testified, mostly that, hey, I'm a good guy, and if I messed up, it was out of ignorance, but you still can violate the law by, as in this case, steering, which happened. I mean, we had two testers testify. One of whom was Caucasian, who said, when I called up, I was dissuaded. He said, oh, now, wait a minute, this is 20% Caucasian, it's 80% minority, I don't know that you should be wasting your time looking at this place. No, I'm okay. In fact, I have an African-American friend there. The school system's not so great. Would you really be comfortable there if your husband wasn't around? She was dissuaded.
Okay, let me ask you a question with this. I also got a little confused with this. Is the Ohio Civil Rights Commission alleging that the steering was steering the Caucasian away from the black community, or was
Correct.
steering the black tester into the black community?
Both, that's steering. You have one group that you want to place in the
But it had to be a
location.
protected class.
Yes, based on race.
And that's why I'm asking which one.
Caucasians steered away while wanting African Americans to live in that location. So it's the saying, I mean, what he should have done is be equally encouraging the Caucasian, not try to steer them away.
They're not a protected class,
That is a protected class.
the Caucasians.
Absolutely, race is a protected class. I can't be discriminated against based on my being Caucasian any more than somebody who is African American. So yes, Caucasian is a race, which is a protected class.
In the employment context, you talk about that's being reverse discrimination, basically.
That's been a term that has been used at times. I don't think it's really correct. It's just discrimination based on race. Looking at somebody, I had one case many years ago where somebody was fair-skinned and discriminated against because the individual felt only African Americans were appropriate for the position. That's discrimination. In this case, it was discrimination based on race, saying to the Caucasian, you really shouldn't want to live there. This isn't right for you, and trying to steer them away. So that was the violation, as proven by the witnesses who testified under oath at the hearing. The second one was a test from an individual who said, I have a son who has an animal assistant. And Mr. Hendy said, well, then I'm going to charge you a fee. And that is illegal. You cannot charge a fee for an animal assistant, an animal needed for somebody with a disability. So the record was established at the hearing showing the violation. The administrative law judge made her determination that these testers were in fact credible, and that determination is owed deference as the trial court provided. Now,
And what is, when you get to the hearing, you have to have probable cause to go forward.
yes,
Okay, and when you get to the hearing, what is the burden of proof?
reliable, probative, substantial evidence, Your Honor. So the question,
For the actual hearing.
yes,
Okay.
you have to prove it by reliable, probative, and substantial evidence. And then the question at the first level of appeal is, did the commission prove its case by reliable, probative, and substantial evidence?
And that is by a preponderance of evidence.
I mean, you could,
Well, you have
you
to have
could,
some kind of
yeah, you could interact.
standard. I mean, you have to know what the burden of proof is in order to go forward.
That whether or not there's reliable, probative, and substantial evidence in the record to support the determination, that's.
But it could be reliable, I'm sorry, I don't mean to be arguing with you, but I'm trying to figure this out. It could be reliable, probative evidence, substantial evidence beyond a reasonable doubt. That's not what we're talking about here.
Well, no, it's not beyond a reasonable doubt. It's simply based on what was credited by the administrative law judge. I mean, it is a civil standard, so you could look at it as a preponderance of the evidence, certainly. And then the question on appeal is whether or not there was reliable, probative, substantial evidence in the record to support the commission's cease and desist order. And then at this level, whether the lower court abused its discretion in finding that there was reliable, probative, and substantial evidence. Now, I want to look at this issue where Mr. Hendy, again, is challenging the Fair Housing Group as engaging in vigilante behavior. It's not vigilante behavior. They're out there testing, they're out there determining whether, they feel there's a violation, and then they turn that over to the commission. The commission could look at these tests and say, you know what, we don't agree with you. We don't think that this shows a violation. But in this case, the commission agreed that these tests, the paired test and the individual test, showed a violation of law, presented it at the hearing, and the administrative law judge agreed, and it's moved on from there.
And I want to make sure, because there's something in the briefs that at some point, I was a little confused with, these were not recorded conversations.
Correct. Not quite correct. They weren't tape recorded or video recorded, but they were recorded in writing by the testers shortly after each test, either contemporaneously with or shortly thereafter, and those testing reports are in the record. So they were recorded in that sense.
Right, contemporaneously recorded in regard to writing notes.
Correct. And then the testers testified at the hearing and said, yes, this is what happened. So it's like any other witness testimony. I say this happened. The administrative law judge listened to them, deemed them credible, and at this point it has to be taken that what they said happened. Again, on the issue of the investigation, of course the commission gets information from complainants. That's not inappropriate. And that's also not the investigation, as Mr. Hendy tries to indicate. He attacks the charge, but he admitted there was a charge in his answer, in his post-hearing brief, in objections, and today to you, he admitted it again. I received it in the mail, it had some boxes checked, that's a charge. He can't admit it at the point when evidence is being submitted and then try to turn around and say, oh, now I want to deny it. And again, what you have in the record is what's established in the hearing. You don't just take the investigation and put it forth, because that's informal and ex parte. What you have in the record is what is submitted through the proper hearing process. Nor did the commission act in an unconstitutional manner. I see I have very little time, so I'll try to address this. What Mr. Hendy is pointing to is actually the statute, which the commission doesn't pass. The legislature passes the statute. And while I understand as a layperson it may be a bit confusing, the fact is the statute is there, it's applied. There's nothing unconstitutional about it, nor does he point to any action by the commission that's unconstitutional. He simply looks at the statute, feels that some of the provisions don't quite gel as he thinks they should. So, Your Honors, Mr. Hendy certainly is entitled to his opinion that the commission should not have found that he violated the law. However, the commission is entitled to determine which of the witnesses it finds more credible, which it did here in terms of the testers, to render its decision. The lower court correctly found there was reliable, probative, and substantial evidence in the record to support that decision, and it did not abuse its discretion in doing so, which is the standard that's before you here today. Thank you.
Thank you. You have just under 5 minutes remaining.
I don't know that it'll take that long, I'll try not to be as wordy.
Fine.
So if I may, Your Honors, let me pull this up. This is page 55 and attachments 1 through 15. And right here, this says, this is to advise you that the investigation of the reference matter has not been completed within 100 days from the charge. Literally right here, they're telling you that they didn't investigate my side of that at all and sent me a letter. The abuse of discretion is that the Ohio State Civil Rights Commission literally administratively changes its statutes, it's in the brief, and they changed it to deny my statutory right to an actual, someone's accusing me and someone does an investigation of both parties. They are sponsoring the parties that are going out and investigating months ahead of time. And then when they get it, automatically in the, I'll give you an example, at the transcript, page 270, line 7 through 20, I put on the stand one of my witnesses that was never contacted, and they were never contacted. No one was contacted, including myself. I never got a call from the commission about an investigation. No one asked me about a thing. No one asked about anybody that I did. Matter of fact, they give you that there were 7 tests taken. That's at page 119, lines 7 through 9. Out of those tests, they only submitted 3. The tests, just so you know, I supposedly discriminate against Caucasians. I supposedly steered away a woman who 113 times has tested people. She's been doing this for 11 years at that point. She literally came there and took 9 pages of notes on pages, let's see, on page 208, lines 6 through 17. I put her on the stand and she admitted that she recorded it. She had 9 pages of notes, but they sure didn't put that into evidence to hear if I discriminated and steered her away. But their only other positive test that they had was for a Caucasian male who supposedly said that his son had a disability and had a service dog. I have a service dog, Your Honors. There's no such thing. He said his son had a problem waking up in the morning and that the dog woke him up because it's a dog, gets up early, got to pee. There was no such thing, but also at the same time, that tester, Your Honor, at page 258, wait, let's see, 258 to 266 is where he describes that and that the animal was acceptable and that he was welcome to apply. So truthfully, if I even would have discriminated against an animal that wasn't told that it was a service animal, he would have had to apply and I would have had to charge him $150. Then I should have got a smack on the wrist and a fine because I did it and I broke the law, but there was no such thing. At page 266, he says that he himself had a great time there and was welcome to come to it. He was Caucasian as well. So out of their 2 tests that they submitted for 2 different things supposedly on race, that it was the Caucasians I steered away, not because they were Caucasian, one, because the girl felt she wasn't welcome, but if you look at the appellate brief on page, which is, I apologize, I've got that. In my, we'll just skip that part, I apologize. So, let's do that let me finish about the dog and the male tester. On page 265, line 17, it says, the tester admits that the people sending them there said, make sure this comes up. That right there is pressure on the 10-year sniper who's worked for them for 11 years to come test you to get that information. I'm telling you straight.
Make sure what came up, that he had a
Make
service
sure
dog?
that they had a dog.
A service dog.
Well, they say that it was supposedly a service animal, but he never said any such thing. He literally said, my son has a problem waking up in the morning, so we have a dog. That's what he said, and I'm looking you straight in the face, ma'am. I have one. So, but that really is a sense, that's entrapment. All they're trying to do is get that answer. So once again, even if I would have done that and he applied and I would have charged them, then I would have broke the law. So if I may, it's still very unclear. I can go into a bunch of different things, but it's still very unclear. Are they charging me under, I'm charged supposedly under Ohio law, but Ohio law is not the same as federal law. Ohio law has sequence. They're out of sequence. Testers came months ahead of time. And what I would like this court to understand and do something about, which is why I'm here. The testers are rampant. There's 2 agencies in Akron, and they call you relentlessly every day. They set up appointments for you to come, and they did it to me 7 times, Your Honor. I drove from Kent down into Akron to show a property. They'll never apply. So really all you're there is for someone to sniper shoot you, to try and trap you into answering a question for you to do.
I'm gonna have to let you know, unfortunately, you have utilized your time.
Oh, I'm sorry.
That's,
I wasn't looking over at the side.
that's okay. Thank you both for your presentations.
May I make one closing statement?
Real quick.
I respect that you both it takes something to get into your role, and both of you have stayed in your role, and I am grateful to have been in front of you.
Thank you.
Thank you, ma'am.
The court will take the matter under advisement. We will issue a written decision, which is mailed to all parties to this appeal, as well as posted on the Ohio Supreme Court website.
Have a good day.
You as well. Enjoy
Thank
the
you.
evening.